inheritors of John Ruggie's mandate, I'm afraid we're not in a position to sue the bastards. First of all, I must make some preliminary remarks by thanking CORE and the Business and Human Rights Resource Center for organizing this event, but more importantly by inviting the working group to participate in this event, because for us on the working group, events like these are more learning exercises for us in terms of how things are happening on the ground that we take into any kind of policy. So we're very grateful for that. But also when I read the program and realized I was the last speaker, and then I saw all the people listed, I sort of assured the people around me, frankly, I don't need to write anything because you're going to say almost everything else that I need to say. But I think I may have misjudged that. And I misjudged that because I realized that one or two people mentioned the working group. And that really creates an interesting fact that as the body mandated to implement the guiding principles, somehow we're not making the right impact in the right places. I was suspecting that the work of the working group will be registered in a lot of what was being said before me. And that really creates the importance of the invitation. In other words, it really makes it critical that at least I should attend this event and at least say some things. There may be some very good reasons why this is so. And it seems like the work of the working group is not sufficiently transparent. And it may be because of the way the United Nations works, because a lot of our sessions are private. Perhaps it's about time we opened them up and made them public. I'm not quite sure we have the power to do that, but it's an interesting lesson to pick up that not many people know what the working group does. And it also relates to events that have happened prior to this meeting, which is the criticism that the working group has received from civil society groups particularly, that the working group is not doing enough on access to remedy, which of course may be a legitimate criticism, but I think it's also because most civil society groups are not entirely sure what it is we do, which is different from not doing enough. So again, another reason why attending the session is quite important, so I can say one or two things about it. So that's a sort of first general remark. Another general remark I should make, of course, is how we perceive Pillar 3. And I've heard, not just at this point, but also heard in previous conferences where somehow there is concern that Pillar 3 is not important. And that may be because there's always a campaign that there may be 3 pillars, but there's only one set of guiding principles, and that Pillar 3 is part of one central holistic guiding principle. And so, you know, it just seems rather uncomfortable to isolate Pillar 3 and then deal with it on its own. I think on the working group, we recognize the importance of Pillar 3, and we actually endorse the idea of isolating the pillars and dealing with them in this manner. And so a conference like this that focuses on Pillar 3 is very important, so we can actually figure out exactly what the problems, well, what's the problem? We have a problem with Kevin. What's that book called? The problems we have with Pillar 3. So we can actually understand. Let's talk about Kevin. Let's talk about Pillar 3. I think it's a good way to go about it, because it is a problem child and we really must understand it. But there's also another structural part of Pillar 3 which actually makes it very difficult to address. And it's because, not only because it's the third, and usually in a very sequential order, we think Pillar 1 is very important. Pillar 2 is important, and Pillar 3 follows it. It just sort of works in our mind that way. But above everything else, we tend to see the entire guiding principles as prospective. And so when people interpret, and I've heard this being taught on a postgraduate course where it's a case of the guiding principles require companies to do due diligence, and they must implement the guiding principles or they respect human rights. When everything else fails, and they've done, and you know, the language in the guiding principles, so, they've done everything humanly possible, and then there are problems, then they should set up a remedy system, which is an unfortunate way of perceiving Pillar 3. Because actually, I would reverse it and make Pillar 3 the problem of now. And in that sense, it's a case of address these sort of problems that you're facing currently, and while you're addressing it, then you can then think of what you do in the future to stop these problems occurring. And so if we reverse Pillar 3 into Pillar 1, or we see Pillar 3 as the problem we have now, we will then begin to deal with it more importantly. And that way we'll begin to understand the place of Pillar 3. So those are my rumblings and my reflections on why I think we're having some of these problems. On the part of the working group, I think certainly we'll try and find ways of being a little bit more transparent so that if for no other reason, at conferences like this, we'll have people who know what to say about the working group. So then, back to the question of what is the working group doing about Pillar 3? To understand what the working group is doing about Pillar 3, we really need to go back to the mandates that we were given in Resolution 17.4 of 2011. And the text is very clear. The language is unequivocal. We were not given a command and control mandate. We haven't been given a mandate to require governments to do things. We haven't been given a mandate to push companies to do anything. Instead, we've been given a mandate to promote the implementation. We've been given a mandate to support capacity building. We've been given a mandate to identify and exchange evidence of good practice. We know, and I think any lawyer who reads the text of the mandate realizes that the mandate is weak, but we have to be able to implement something out of it. So that's usually one of the difficult starting points. So with this kind of mandate, the understanding is that the primary role lies with states, businesses, and civil society, and our job is to promote and to support. But if you're only supporting and promoting, there is no express mandate, for example, to deal with complaints, if you wanted to read it in its natural sense. But over the last 3 years, we have tried in many ways to interpret words like support, words like promote, in slightly more imaginative ways to make Pillar 3 slightly more effective. So for example, although we are not specifically given a mandate to deal with communications, we have a policy on communications, and I'll come to that in a minute. But in the meantime, one of the things we've done is to take advantage of existing access to remedy mechanisms and try and push our implementation of the guiding principles through them. So the OECD's national contact points, for example, become a key part of our understanding. The ILO's communication mechanisms, we have tried to use them as much as we can. And then the treaty bodies that already exist, that receive communications, we've been encouraging them to receive communications concerning businesses, and we have tried to do that. But similarly, on our own, we have received quite a few direct communications to us concerning corporate activities. Bearing in mind the text of the treaty does not specifically empower us, and we know, for example, that in certain special procedure mandates, like the ones on disappearances, have been given express authority to receive and judge and address communications, where we haven't. But nevertheless, we get these communications and then interpret it in the light of the mandate that asks us to identify and explore evidence of good practice. Well, to be able to identify evidence of good practice, you need to understand what bad practice is. And to get a full understanding of what the bad practice is, you go back to the person against whom the complaint has been labeled to say, listen, we're exploring and looking for evidence of good practice. But meanwhile, we've had this suggestion that you have flooded a community's farming land. Could you please explain to us exactly what is going on? And do you realize that this could be contrary to your responsibilities to respect human rights? We write that to the subsidiary company, we write that to the parent company, we write to the host company, and we write to the home company. Now, this is all being done under the heading, or not of dealing with the communication, but we are dealing with sorting out evidence of good practice. And over the last 3 years, yes, we have had some responses, and we have had some explanations, and we have had clear indications where some companies have gone back to try and rectify issues of consultation, issues of damage to land. This, as I say, has to be done under the radar. Otherwise, there are members of the United Nations that will think immediately that we have exceeded the mandate, and we don't put it past them that they will shut us down. So in many ways, it's quite important that we understand how we do this. However, it turns out that the work that we've been doing on communications has indeed come to the attention of states. It just turned out they ignored us, and we're quite happy to be ignored. But the consequence of the recent negotiations with Ecuador and South Africa turned out as one of the indications that the working group has indeed been dealing with communication is to propose to Ecuador that that particular mandate be strengthened. And if you read paragraph 12 of our resolution, we've been asked now to continue the good work that we do in the consideration of communications. For us now, as from now, we now have an express mandate to receive and deal with communications. So suddenly we now can, in a very open manner, write to Amnesty International and ask for your thoughts on a particular communication, and we'll let the companies know. So we think things are evolving, but at least we had to be a little bit more imaginative in the first place before we come this far. Of course, how we now carry it forward will depend upon what communications we receive. And by the way, we talk about a lot of issues, and we know about instances of violations, but for some strange reason, we know where they are, but we don't receive these trigger communications. For a very short period, we started receiving a lot of communications from the Latin American region, and that's where most of the activity is. In the last 3 years, we have received one, and I mean the single one communication from the entire African continent. I don't believe there are no violations of corporate violations of human rights in Africa. So of course, the responsibility has to be shared. We like to think that, if we're really going to be doing anything on access to remedy, we need to be triggered. And some of the civil society groups can help in that. That's just one of the ways in which we do. And then we come under the heading of promotion. Now, through promotion, we have to interpret in such a way as to strengthen and support institutions and mechanisms that already handle disputes. So national judicial systems, national human rights institutions, and corporate grievance mechanisms. Now, the best way we've tried to put this together is under the wider umbrella of national action plans. And in that very nebulous label, we have been able to put everything, including states' activities, corporate activities, civil society activities, and national human rights institutions. It is under this heading that we expect that states will identify and remove the sort of barriers that were mentioned this morning. This is the same heading under which we expect states to help develop capacity within the judicial system, capacity within the legal professions, capacity within educational institutions about the guiding principles, and access to remedy. This is the same heading, national action plans, where we expect them to explore areas of cooperation with other states, which I dare say for those of you who haven't quite captured the language of the working group, when we talk about interstate cooperation, we mean these are the headings in which they should be talking about extraterritorial jurisdiction and on exchange. And we think they ought to be talking about that in their national action plans. We also imagine that this is the point where they should be supporting and incentivizing, if necessary, corporations to have robust grievance mechanisms. I'll give you a very simple example. Sierra Leone has developed a policy on sustainable agriculture, in which it has three sort of incentivized models. The first level is to do with the negotiation of access to land, so that if you consult in the appropriate way, you get sort of points for it, and a few other things that you have to do. And if you do all the things that Sierra Leone requires before you access the land, you get 5% off your tax payment. And then if you go to the next point where you do due diligence and you do all the things that's incorporating the guiding principles into your policy mandate, and you connect with your parent, or your parent agrees to take some responsibility for the activities on the ground, you will get up to 10% off your tax. And suddenly, we see companies suddenly thinking, okay, what shall we do? How do we get the guiding principles into our policy? How do we do diligence? But of course, all of this comes under the wider umbrella of national action plan. So through these same national action plans, encouraging states to have these sort of incentivization process, you could strengthen national human rights institutions' powers. You could actually even get corporate grievance mechanisms to strengthen. But this comes under the wider heading of promoting. Now, finally, I should say now, and I expect everybody expects me to make a comment on this, and what does the working group think of the new open-ended intergovernmental working group? And I should say that I read a statement to the Human Rights Council, which is more or less the official statement on that, which is to say, amongst other things, that we think that if the responsibility for further normative development rests with states, and that if states develop an intergovernmental working group, we are delighted to work with it. So, of course, since the working group has been now passed, we welcome the working group, because we think it offers us an opportunity to strengthen our mandate and do the sort of things that we couldn't do before. And it provides that opportunity of what the phrase was, complementarity, to work together. And we think, in the light of our new resolution concerning communications and its endorsement of national action plans, which of course we're currently working on, an endorsement of our communications work, plus the possibility of cooperating with the new intergovernmental working group, we may see a little bit more activity on the working group concerning Pillar 3, in the hope that by the next time when Business and Human Rights Resource Center and CORE call this meeting, there will be no need for me to attend this meeting because almost everybody else will be talking about nothing else but the work of the working group. So thank you very much.